We are ready to go to have an intellectual conversation. Again, I'd love to have you over here, Mane, because you are one of our high intellects in the office. You make me look good. So we're going to talk about an appellate court decision today that's entitled Brubaker, or Brubaker, I don't know, and Strum. And it's a 2022 case, right? Was this published in 2022?
Oh, well, yeah. It was certified for publication right in the beginning of the year.
Okay, so this is hot off the press, brand new Spagan. You know, people out there have never heard this, so we're going to give you a glimpse as to what 2022 is going to look like. Tell us about the facts of this case.
Okay, sure, no problem. So the facts of the case were obviously husband and wife going through a dissolution, had twin boys. Actually, I don't know if they were boys. They had twins going through a dissolution. At the same time as, or close to, within weeks of filing for the divorce, wife also files for a domestic violence restraining order.
Now, this occurs in Los Angeles County, right?
Correct.
And we don't have to go through all the names, but when you read the decision, you know most of these judges that are named in this here, the trial judges.
Yes.
Okay, which
Yes.
made it more interesting for us, but go ahead.
It definitely did make it more interesting. So wife files for dissolution. At the same time, she files for a restraining order. While the dissolution is still going on, so think of it as two different matters, they enter into an agreement for some stay-away orders between a husband and wife. So the first restraining order gets resolved sort of by...
Can we stop right there? Did you read that to think that was a non-klutz restraining order or like an agreement?
That's how I understood it, because then she filed for a second one.
Yeah.
So I think that's what it was.
So our listeners should understand that there was a technique or a trick that people used to use, and that is we're not going to really agree on we're not going to have a domestic violence restraining order because we don't want to have that on somebody's record or anything like that. But what we're going to do is we're going to agree that the offending party will stay away 100 yards, will not have any contact directly or indirectly, shall not harass, threaten, or foul, stalk, anything like that. We'll put that in a regular stipulation. Both parties will sign it. The judge will sign it. It will be in the court file, but it won't go into the klutz and things like that. Well, we've been corrected. The whole profession was corrected to say that the code says that that's a protective order, and therefore I don't care if you put it on a napkin and it gets signed by the judge. That's a protective order, and that's what seems like happening here, because it doesn't really talk about it doesn't read the way we normally do about somebody going in and obtaining a domestic violence restraining order, right?
Right. They called it a stipulated temporary protective order.
Yeah.
So at first I thought it was maybe something in between the time of the actual hearing comes around for the permanent restraining order. But no, I think that just resolved the first restraining order that she had filed. Mm-hmm. So then she filed the second
It could have been this other thing, I guess, where there's a TRO and the husband's attorney says, look, we're not fighting it, but why don't we work something out so that it gets dismissed after a certain period of time. So we'll stipulate to it. Something like that. I don't know.
Maybe, because it said he's to stay 100 yards away from the wife, except on school activities, and he couldn't contact her except in connection with custody of the kids. So.
Okay. Well, I don't know if that's even, all the stuff that I'm saying is even germane to the case, but I found that interesting. But go ahead.
Okay. So that was in November 2017, so not much after that, a couple months, beginning of 2018, wife filed for a second restraining order, alleging that husband was violating the terms of their stipulated protective order on multiple occasions. He was stalking her. He was monitoring her using a nanny cam, harassing her verbally, lashing out, things like that. So there was an actual hearing on the second restraining order, which resulted in a 2-year restraining order protecting the wife from the husband.
And the judge in that case, who I want to name, but I won't, he made some comments about, the seriousness of the offending party's conduct, right?
Yes, I think what he said was it was situational because of the divorce. So he felt like 2 years was enough because once the divorce was finalized, then they wouldn't have to interact, and and she wouldn't need protection from him.
And he was wrong, right? I think that we always hope, and judges want to be fair. They want to look at both sides and understand that it's emotional and stuff. But this particular judge thought, you know what, this is not something that this man normally would do. He's probably not going to do it in the future, so he entitled it situational. And, based upon that finding that it was situational, he didn't give a 5-year restraining order like he could have. Instead, he said 2, because the courts have that discretion,
Yes,
right?
correct.
Okay.
At the same time, wife was granted sole physical and legal custody of the kids.
And why would that be?
Well, because of the presumption in the family code,
3044.
44 presumption, yes.
Yeah. Now, I don't know if there has to be a sole legal custody, but certainly sole physical custody under the code. So, there's a finding. That means that he can't have 50% custody. He can't even have anything near that, all right, because there's a finding of domestic violence. Now, is there a way of getting around 3044, the presumption?
Yes, so it's a presumption, so it could be overcome. And there's various factors that is listed as under the code that, if you do these things, then the court might consider these in determining whether you overcame the presumption.
Anger management classes?
Yeah, anger management, batter's intervention,
parenting classes? Individual therapy?
Even just the passage of time.
Obey all laws?
Yeah.
Generally a good guy.
All that good stuff.
And none of those things are required. They're kind of suggestions by the code, right? Like you said, after the court doesn't have to find that happened, but those would be good things for somebody to do if they get a restraining order, right?
Yes.
And they want to restore their physical custody. So that's that's a state that they're in 2018. Now, what happens next?
So keep in mind that the divorce is not yet finalized.
Okay.
So what happens is in May of 2018, so maybe 6 months later or so, wife goes in and says husband has violated the terms of the 2-year restraining order. Basically, he was abusing Our Family Wizard, which is what the program they were using to communicate about the kids, that he was using it to scold, admonish, and reprimand her.
We never, I don't think on the podcast really talked a lot about things like Our Family Wizard, but there's now a variety of computer applications that allow parents to communicate with each other. There's Our Family Wizard, Talking Parents. Do you know of any other ones?
No.
My wife Maria sent me one that I guess there's now a thing that's called co-parenting.
Well, because people can't just text or call anymore. Now they need.
Well, I was thinking, how many of these apps do you have? And they're competing, with one another. I think that the Talking Parents is practically free or something. I love Our Family Wizard. Yeah, and I love Our Family Wizard because it's got a lot more bells and whistles and stuff. But they're all great. And the idea of the app is not only does it provide a platform for these people to talk to each other, but they could be monitored, right? Mm-hmm. And if you post something on one of these things, you don't get to press the erase button or anything like that, or come to court and go, look at these messages, but leave out all the rest of them. And quite frequently, we attorneys get access to those because that's allowable, and we could kind of watch it, or the court could even do that. So that's what these people have. They're on Our Family Wizard, and this guy is not peacefully communicating about the well-being of the children, right?
Correct.
He's making some statements.
Yes.
Okay, and then what happens?
So this is a different judge, not the judge who issued the restraining order, but a commissioner who I'm assuming was handling the case in the home court. She said that this constituted a violation of the restraining order, and number 2, she limited the scope of the Our Family Wizard communication. So it was less than what it was before, so he wouldn't continue violating the order.
I think I missed that part of it. So that was was that like the May of 2018?
Yeah, May.
Okay, all right, I missed that part. So then in 2019 they go into court, right?
Yes, so the case is still going on during this time, the dissolution, and finally on July 23rd, after a couple of days of trial, there's a different judge now. The trial judge issued a final disposition in the case, a final decision, and one of the main issues was whether the dad had overcome that 3044 presumption we were talking about earlier.
What did the judge say there?
So the court found that he did not meet his burden of overcoming the presumption, and that having joint custody, at least at that time, would not be in the best interest of the kids.
Okay, and so he said, let's see, wife was still negatively impacted by the husband's abuse, and the husband's inability to control his anger had been detrimental to the children, right? Is that was part of his thing? And
Yes.
So he's basically saying, look, sir, I'm not going to find that you've overcome the 3044 presumption, giving you more time, okay, because you lose on that. But the judge made a statement during this that ended up being the big issue. What did he say?
So he said that although he did not overcome the presumption, he did not violate the terms of the restraining order, the 2-year restraining order that was in place at that time, that he complied with the terms of the permanent restraining order, and he had not committed any further acts of domestic violence since the order had been issued.
Basically, what the judge was doing was just kind of like going through what he believed he had to look at in order to determine if the 3044 was overcome. The presumption was overcome, and so he kind of said some nice things about the husband while he was denying him. Is basically what was
Exactly.
going on. Okay.
Exactly.
Then what happened?
Then a final judgment on the divorce was entered in November of 2019. And in October, so about a month before that happened, the wife filed a request to renew the domestic violence restraining
Because
order.
we're outside of the divorce, right? Which we just talked about. We're talking about the restraining order, and going back, it was only 2 years.
Yes.
So when the last time they were in court, they weren't there for the purpose of getting a new restraining order or renewing it. They were there regarding custody of the divorce. But shortly after that, now they're in court,
Correct.
and she says, I want to extend it. I'm
Correct.
not asking for a new one, but I think that the expiration date was not good enough, and now I want to. So can we talk a little bit about what happens when people do that and some of the basic rules
Yes.
of how to get that?
So first of all, you could, within 3 months of the expiration of the restraining order, you could file a request to renew, and it could be renewed for 5 years or permanently.
Isn't that incredible? Permanently. Okay. So 3 years, within 3 months?
3 months,
So that means that you can't come in earlier.
Well, actually, the wife in this case did go in a little early, but nobody
Said anything.
said.
So the Court of Appeals
objected.
said you didn't say anything about it, so it doesn't matter. But really, if she was called out on it, she would have been wrong because you can't go in. I didn't know that until I read this, by the way. So it has to be 3 months before. And I know one thing is you can't ask after it expires. Once it
Right.
expires, you're done.
Right.
If you didn't put in your request before that, right? But also, even though it was just a 2-year restraining order, if the court grants it, the minimum is 5 years, and it could be up to life.
Up to life, yeah.
Which is powerful because we know that a lot of judges will just say, you know what, counsel, you've met your burden, but I'm just going to do it 6 months restraining order or 1 year. That person could go back in front of a different judge, a year later, and boom, they got a lifetime or a 5-year. So it's a very powerful code,
Yes.
and that's what this man was facing. So what happened next?
So I think it's important to discuss the legal standard by which the courts are to decide whether to renew the restraining order or not, and that is whether the restrained person, or I'm sorry, the victim, I guess, has a reasonable apprehension of future abuse based on the conduct that could have been in the initial restraining order, or things that happened after it. So
It's kind of murky.
Right.
It's kind of vague.
Right.
It's weird, but what you're talking about is really the crux of not only this decision, but we've seen a lot of them, is what does it require to prove in order to get that renewal? Because we know that you're not asking for a new restraining order, right? So you're not really coming in and saying, I got to prove, by preponderance that there's been additional domestic violence. The code says that that's not required. But it says that you have to have this reasonable apprehension of future fear, and it could be based, on the underlying incident, right?
Yes.
I mean, if it was a very serious incident, they're really doing the reasonable person standard again, I think.
Exactly.
Right? Under similar circumstances.
Exactly, and you don't have to show that the person violated the restraining order either. That's not required.
Okay. Now, let's assume that there was no violation, but the restrained party was doing certain things that would make you nervous. Had you been the victim of that person. Did we see any of that in this case?
I think we do, yeah. I think that definitely happened because Like we discussed, he was using this talking platform to harass her, and he was being nasty during the custody exchanges.
Things that wouldn't necessarily get you another restraining order, but certainly, kind of acting, aggressive again, right?
Yes.
Okay. So what happened in court?
So husband or his attorney filed 2 motions in limine, which basically are, hey, keep this out of, dismiss the action because of these legal or procedural flaws. So the first motion in limine, I believe, was not really discussed because they agreed to, they wanted to exclude some messages on Our Family Wizard, which the wife agreed to. The second motion in limine, which is the reason for the appeal, was a little more complicated. So they sought to exclude.
You know what, for our listeners, what's a motion in limine?
I thought I touched on that in the
Did you?
beginning, but
I don't know if you did or not.
To say, hey, throw this case out because there's procedural defect, or they shouldn't be allowed to exclude evidence because of these legal reasons.
So it is what it sounds like. It's in limine, meaning that it's before we even get into the evidence of this case and stuff. You're saying, Judge, even before you open up the door for the litigation here, I've got some motions to exclude, and that's what we're talking about at that stage, right?
Right. So they were trying to exclude these messages, which the wife said, fine, I agree to that. And then the second one was they were trying to exclude any testimony from the wife of any evidence regarding allegations of abuse for a specific time period, which was they were trying to exclude everything basically up until the point where the family court had issued its decision in the divorce. So
can we go back to that now?
Yeah.
Explain what that was.
Yeah. So they were saying exclude everything that happened previously. You can't talk about the abuse that occurred before the restraining order, the abuse that caused the restraining order to be issued, or anything that might have happened after that up until February, up until I believe it was the summer of 2019 when the family court issued its final decision in the divorce.
Yeah, and so the legal term that they're using to make this motion in limine is what? What's the legal claim?
I believe it's collateral estoppel.
Yeah, or issue preclusion.
Issue preclusion,
right.
Yes.
And we're not going to get into a very detailed analysis of that, but something we learned in law school. But I think just for our listeners, again, the folks that are just maybe barely hanging on to this, is that judge who in the divorce case said, I'm not finding that there were any further domestic violence incidents since the restraining order went into effect. Nevertheless, I'm denying the increase in custody because you haven't rebutted the 3044 presumption. But I'm finding that there were no other incidents. That's what they're talking about. They're saying that this judge already decided that during that time period there was no domestic violence. And so they're saying, issue preclusion, Judge, you here later on can't or should not retry that issue because it's already been decided.
Exactly.
Okay.
Exactly.
Now you get the fun part is to talk about how the Court of Appeal dealt with the issue preclusion because it's very, very wonky in my mind.
Yeah, it's a little complicated. The trial court actually, so the wife's request for renewal was denied because her the evidence she was allowed to present, the court felt like was not enough to meet that legal standard of reasonable fear. So it was denied.
So the trial court granted that motion to exclude. It said, you're right, this is issue preclusion, so you're precluded from doing that. Ma'am, call your first witness, but it's got to be really recent evidence here, right?
Exactly. So she was limited to a specific time period, and she testified, and the court felt like, the things that had happened were didn't put her in reasonable apprehension or reasonable fear, so it was denied.
She appeals?
She appeals. She timely appeals, and the Court of Appeals reversed because it held that. Do you want to get into that now? Or?
Go ahead.
Okay.
Take a shot at it. I don't know if I could do it, so I'm dependent on you.
I'll try. So
okay.
What the court held, without getting into the specific, factors as to
what issue preclusion is.
What issue preclusion is. Basically, what the court said was. The trial court, the issue of the trial before the trial court was whether the dad had overcome the 3044 presumption. the issue at the renewal hearing was whether wife had met the burden of showing she had reasonable apprehension or reasonable fear in the future, and these two are different.
Apples and oranges.
Exactly. So they're different issues, and she shouldn't have been precluded from presenting evidence before, after, during the time of the original restraining order, and that could have, though that evidence should be considered. So the court has to. That was the instructions on remand were, she has to put on the evidence, consider all of her evidence as to the abuse, and then decide whether it's going to be renewed.
Yeah, so the Court of Appeals said, I'm sending this back to the trial court. Mm-hmm. Now you have to listen to the evidence because the issue preclusion was wrongly decided. Mm-hmm. She had the right to put on this evidence. And by the way, when the judge made the comments about there being no evidence of domestic abuse, it wasn't really like he was making findings of fact anyways. I mean, he was basically saying, I'm not aware of any. But more importantly, is apples and oranges, right? Mm-hmm. So what's the practical application of this case? You know, for me, I'll go first here. I'm thinking that when you get a reissuance, you kind of get to go back in time mm-hmm. and talk about the underlying issue, because that's what it's saying. You can't preclude testimony of what the person underwent, because you want to talk about the gravamen of the original offense. If mm-hmm. this was a really serious physical assault on a victim, mm-hmm. There's got to be some reference to it, because that's what the court has to kind of decide, right? Mm-hmm. Unless there's stipulations to that. You also get to talk about all the other things that have happened since then that would cause a reasonable person in those circumstances to be fearful, right?
Yeah, exactly. The court and the Court of Appeals said that the existence of the initial order certainly is relevant to the request for the renewal, and the underlying facts and findings supporting that order will often be enough in themselves to provide the necessary proof to get a renewal.
So there's some circumstances. I've heard enough. I mean, why wouldn't you be fearful, right? Mm-hmm. But then again, you have to ask, if you go in front of that same judge, then you go, why did you just make it 2 years?
Right.
But what I look at this is that currently the County of Los Angeles is inundated. I don't know if this is true throughout the state of California or throughout the United States, but our courts are inundated now with hearings regarding restraining orders. Mm-hmm. I mean, they take up a lot of time. You and I have done some that have lasted 5 days, mm-hmm. and they're more complicated and more heavily fought than many of the criminal cases that I prosecuted or defended against. Mm-hmm. I mean, they're very, very gnarly, and that costs money. You've got the court reporter, the bailiff, the judge. You've got, people inside the courthouse, arranging for the paperwork and stuff like that. And then the attorney's fees, of course, related to that. But mostly the strain on the system, mm-hmm. to the point where recently there's been some pushback about, not every case is going to be a long cause matter. Yes. And we're getting pushback from the Superior Court because of this stuff. But that kind of, conflicts with this, where it says you get to put on this evidence. Mm-hmm. So what do you think is going to happen?
I don't know, because like you said, many judges are limiting the time you have to present evidence.
Which is impractical in a lot of ways, because right. I have a case right now where the judge said, counsel, you think this is going to last just a day? Well, this is going to last 3 hours, no more than that. And I'm thinking, okay, I'm talking about my examination. My own witness is going to be an hour and a half. And then I know cross, because people can't get enough of cross, man. That thing's going to last 2 or 3 hours, right? Good luck in making that a 3 hour estimate.
I mean, what happens if you're not finished with your case in chief?
Yeah, I think I might have told you this. I was telling, I think, Stephanie, that there was a judge in Orange County. We used to call him Fast Eddie. Yeah. He would do entire jury trials in a day. Okay, call your nose. Okay, you're done. And he'd just rush it and stuff like that, and the people would get done. But, I don't think that's justice. I mean, in a particular case like this, where, they're saying that justice is you get to talk about the past, right? Mm-hmm. Very, very interesting, and I think that what they ought to have in L.A. County, if anybody's listening who could care about my opinion, is they may want to think about getting a court system for just domestic violence cases. People that are victims, and even people that are wrongly accused, should have the right to be able to put on their evidence. I mean, the consequences, which we're not going to talk about in this one, are severe. They especially when you're talking about custody and support and things like that. The law, it could come down on somebody really hard, and stuff. And so why don't we give these people the time to really try these things? I understand the system is, buckling right now, but somehow, some way, we've got to come up with a different system, I think.
I agree.
So, all right. Are you ready for your next domestic violence case? Okay. Well, you did a great job again. I think we're going to talk about this in our attorney training tomorrow because this is a really important case, and you did a great job.
Thank you.
Thank you. And thank you for attending or listening to our podcast again, and we'll see you next time.